Welcome once again to our continuing YouTube video series on aspects of business law. My name's Christopher Neufeld of Neufeld Legal, and in this particular video we will be discussing the aspect of unanimous shareholders agreements. And what is a unanimous shareholders agreement? It is an arrangement set down in writing by all the shareholders in a given corporation. And what does it do? It sets out the mode of operation of that corporation, voting mechanisms, exit procedures, and outlines rights and responsibilities of the shareholders as to the corporation. And in so doing, it provides a more specific framework that is fitted to the business arrangement and the particulars of the shareholders and the business that they're undertaking. And why is this done? Well, it is done because the articles of incorporation, the bylaws of the corporation, and the governing statute from corporate law is typically not sufficient for purposes of dealing with many matters pertaining to a corporation and its activities as in between the shareholders. And this was done for a very specific purpose. And that purpose is that it tried to avoid creating a one-size-fits-all system for corporations. Instead, corporations are allowed to determine their own course, their own operations, their own plans, and the shareholders thus are entitled to come to their own agreement as to what they have in place amongst themselves and how they will operate. Now, what are the main aspects that you deal with in a unanimous shareholders agreements? Well, we could go list off a series of basic aspects, but we'll just touch upon two of the more critical aspects and the ones that have some of the greatest focus that needs to be put forward to them. The first one is the aspect of voting, and the second is the exit strategies. With respect to voting, we look at such aspects as how do you determine who the directors of the corporation are? How do you determine who the officers of the corporation are? You set forth that in the unanimous shareholders agreement. You also set forward aspects related to meetings both of the directors and the shareholders. And then you get into the particulars of voting. And when I talk about particulars of voting, I talk about what are the thresholds for a successful vote. Because typically, if nothing's set out, the voting standard is 50% plus 1. So there may well be arrangements, especially as you get to more shareholders, where you look to either have unanimous consent for certain things. So if there are 2 shareholders or 3 shareholders, all of them have to agree. There might be arrangements that require a 75% vote, a 2/3 vote. That is what is set out in your unanimous shareholders agreement typically. The other important aspect that is set out in a shareholders agreement is the aspect of exit strategies. Now, when I talk about exit strategies, these are your arrangements, whether it is if you want to remove a shareholder, technically buy them out, you want to sell off, a shareholder dies, a shareholder becomes disabled, a shareholder commits a default events being such as personal bankruptcy, fraud, criminality, even a divorce. Those aspects can effectuate a default and require the sale of the shares because a non-party would effectively come in and assume those shares, and that is something that the other shareholders will not typically want. It would also address the exit aspect of when a corporation finds itself a willing buyer. So we'll touch upon each of these aspects, starting off with the most commonly discussed exit strategy, which is the shotgun provision. So a shotgun provision is an arrangement where one shareholder effectively says to one or more shareholders, I want to buy you out. The way I'm going to buy you out is I'm going to set a price per share, and I'm going to pay that price typically. You have the option to either take that price or you can match that price and buy me out on a per share basis at that same price, given proportionality differences. Either the other shareholder accepts to buy the offer out or will end up selling. There is no optionality of not doing anything. They have to either come up with the funds to buy out the offering shareholder and fulfill the buyout arrangement at that price, or they will be bought out at that offering price. Now, an alternate version of that is putting in a put-call mechanism. And a put-call mechanism tries to provide a fair arrangement in some respects, in the sense that it puts a more equitable pricing scheme in place. So let us say a shareholder wants to buy out another shareholder. What they would do is they would say, okay, I'm going to buy you out. What is the fair market value of the shares? You're going to have a mechanism, the shareholders agreement, to determine what the fair market value is. You're then going to pay a premium, let's say 20-25% above that, and the payout would be immediate. On the flip side, if a shareholder were to call and request that their shares be acquired by the other shareholders, instead of having a fair market value with a premium paid, there would be a discount on it. And instead of it being paid immediately, it would typically result in the payment being made over a period of time, given the fact that it is an unplanned event that the corporation and the other shareholders are going to have to assume. This premium aspect and discount aspect sort of has benefits and disadvantages to it, and we will discuss this in other videos. As for death scenarios and extended disability scenarios, what the shareholders agreement does is provides a mechanism to facilitate the acquisition of the shares by the corporation. It provides, where possible, oftentimes the acquisition of insurance against the life of the shareholder. However, the reality is that such insurance is rarely obtained, and especially as the company becomes more significant and the cost is just more significant than the company is capable of paying. Now, what happens with respect to a death provision or extended disability is, once again, we look at the fair market value of the shares, and that amount, after determination, would be paid out to the estate of the dead person or the permanently disabled person, but it is paid out over a period of time. Once again, the arrangement is designed to facilitate the corporation having the liquidity to continue with its business and to make those payment arrangements through the process. The corporation and its shareholders may at the same time pursue other new parties to buy out those interests, but that is an uncertainty, and hence the arrangement calls for one baseline, but which can be developed. The other arrangement which we alluded to is that of a default situation. For example, where one of the shareholders becomes bankrupt, commits a criminal act, commits fraud with respect to the corporation, or other malfeasance to the corporation, or gets divorced, such that a new party external to the corporation will potentially become a shareholder in the corporation, and the original shareholder has divested or otherwise lost their rights. In those circumstances, the Other shareholders in the corporation naturally do not want to have this other party coming on, and this party has really no interest in most cases of being a shareholder to the corporation. The thing is, the other shareholders do not want to be paying the current price, especially where there is a degree of malfeasance of some form or another that has hurt and impacted the company. As such, let's say a bankruptcy trustee, they will look to provide fair market value, but at a discount and priced out over a period of time. And this will give them negotiating ability with respect to how they might deal with the payout of the bankruptcy trustee or other parties. The intent is to allow the non-harmful shareholders and the corporation to avoid having to pay for the sins of this other shareholder when they were not a party to it. That is why there is discounts and gives flexibility for negotiating. The other aspect of exits is with respect to facilitating a sale of the shares of the corporation. The last thing you want to do is have a couple of shareholders find a very good opportunity to sell the business at a quality number and then have that opportunity ransacked by one minority shareholder who says, I don't want to divest my shares, or I'm going to demand a very extreme premium. I'm going to take it to court and be tied up in court for an extended period of time. So instead, you want to have a fair and reasoned procedure through which the company can be sold, the shares can be sold, if there is that sufficient majority as is typically required in what are known as piggyback and tag-along provisions that are contained in unanimous shareholders agreements to facilitate the sale of the shares of the company to interested third parties. Naturally, there are degrees of protections that need to be provided. As with everything else in shareholders agreements, protections are at a premium. I trust this has provided some elucidation into the aspect of a unanimous shareholders agreement. Naturally, there is far more that is involved in these agreements because of their pure complexity and the specificity that they may have to the various companies for which they serve. As always, we are available as a law firm to undertake unanimous shareholders agreements and other corporate and business law matters. We thank you very much for listening to this video and look forward to speaking to you, and we welcome you to subscribe for further business law matters. Thank you.